Hello, my name is Janine Burmania and I'm a licensee manager at the Wisconsin Alumni Research Foundation. And today I wanted to give you a brief overview of agreements related to intellectual property. A previous video gave a detailed discussion of the different types of intellectual property, so today I'm just going to give you a brief overview. Mainly when people think about intellectual property, or IP, they think about patents, which protect inventions such as materials or compositions of matters, as well as machines and processes. Other IP includes biomaterials, which is physical matter such as cell lines or antibodies, copyright, which protects original works of authorship such as software code, trademarks, which identify and distinguish the source of a good or service, and trade secrets, which are simply that, what an individual or a company wants to maintain as a secret. And intellectual property rights are important because they give the owner the exclusive right over their invention. And often IP can be one of a company's most valuable assets. And IP rights are important because they're identifiable, protectable, transferable, enforceable, and licensable. And so that's what I'm going to talk about now, license agreements. And a license agreement is a contract between the IP owner and usually a company, which I'll refer to as a licensee, and it gives the licensee the rights to make, use, or sell your invention. Licensing can be important to a company because it allows them to bring in new technology that they otherwise might not have experience with in their R&D group, as well as reduce their time of R&D as well as their time to market. In a license agreement, there's many things to consider. Such things include the measure of exclusivity, which is, are you going to license the technology to only one person, or are you going to do it non-exclusively and try to license the technology to a number of people? Other things could include the field of use. Technologies usually have multiple different applications, and sometimes a company can only develop that in one area, so you limit the field to that specific area. There's also the territory that you're going to allow them to make, use, and sell the invention. You can have patents in the US as well as in foreign countries. Sometimes companies only focus on the United States market, not the foreign markets, and so you could limit the territory to the United States only. There's also financial considerations such as license fees, royalties based on product sales, or patent reimbursement, or milestone payments, as well as development requirements, which make sure that the technology is developed by the company, not just shelved so that way their competition can't use it. Other types of agreement outside of license agreements include confidential disclosure agreements, material transfer agreements, standstills and option agreements, as well as research licenses. Confidential disclosure agreements, sometimes referred to as non-disclosure agreements, are agreements where parties agree to keep their information confidential. So I'm going to tell you something and you're going to agree not to tell anybody else. This can be very important with information such as trade secrets, which are not patent protectable, or in information that you haven't yet included in your patent. And so many times these are done at the early stages of the invention process when you want to talk to a company about your invention and see if they would be interested in licensing it. Material transfer agreements are used both by academic institutions as well as industry to share their biomaterials or other forms of materials with each other for research uses. These allow the receivers to the materials to use it usually for a specific purpose and for a given amount of time. They limit the receiver's ability to distribute to others and often have rights to new materials or inventions that are developed using this material from the IP owner. Standstill and option agreements are agreements by which the IP owner agrees not to license the technology to a third party during a given period of time. So if a company comes to me and they say, I'm kind of interested in this, but I need a little more time to evaluate the marketability or the feasibility of the product, they could enter into a standstill or an option agreement with the IP owner, and I as the IP owner, would agree for a specified period of time, usually 6 months or so, that I would not license that to anyone else during that time period. And at the end of that time, I would then enter in negotiations if they were interested for a license agreement. The other type of agreement I was going to discuss today is a research license. And this is usually for between the IP owner and a company. And it's similar to an option agreement in where the company still needs to do a little more work, but at this time it's actually the company bringing in the technology in-house, doing some work with it to explore whether or not they could develop a product. or it could be for a biomaterial where they want to bring the technology in-house, use it for internal uses only, and never develop a product based on that material. So these were just a few examples of agreements that people can enter into regarding their intellectual property. Thank you for listening.